Good evening, everyone, invited guests and fellow members. It has been said, and I agree, that the good thing about these amendments is that the ensuing discussions result in a civics lesson. And the truth is that our Constitution is something that many of us as citizens are only just beginning to pay attention to. I'm not sure that the Constitution is taught in schools, but it certainly should be. The simple version, though, is that the Constitution is an 89-page document, well, online it's 89 pages, that forms the operations manual for our nation. Incidentally, and as a point of interest, the word freedom appears in the Constitution 44 times. Tonight we're here to learn about the 9th Amendment to the Constitution, the proposed 9th Amendment, the meaning behind the words of it, and the possible consequences if those words become law. We will, I'm sure, not let go of the legal experts here present, we have a few of them actually, until we feel we have a full understanding and that we can then explain what we understand in layman's terms to those with whom we interact on a daily basis. If you saw the debate last night, you probably have a fairly good understanding of the topic by now. But this is also your chance to understand more. We never know everything, do we? And it's a chance to ask questions that may not have come up at last night's debate. Such a critical discussion needs to be aired often, at length, and in depth, and understanding can only grow from the airing. Before I hand over to the presenter, to Ms. Jackie, one quick word regarding the separation of powers. Last night, Senator Hulse brought up Section 59(2)(e) of the Constitution, wherein a member of the House shall vacate his seat in the House if he resigns from his political party or crosses the floor. Crossing the floor is generally interpreted to mean voting against your party. Since representatives of the majority party in the House cannot, by virtue of this section, go against their party, which also forms the cabinet, the reality is that in daily practice, the legislative and the executive branches of government act as one. This leaves the judiciary as the only check on Parliament's powers. Any attempt to remove the courts from the debate is then tantamount to removing the only method by which citizens can attempt to curb Parliament's powers, except, as we were reminded by the Honourable Minister of Foreign Affairs many times during last night's debate, for civil disobedience and general elections. As you go through the 9th Amendment and over the next few weeks, you hear all the arguments pro and con. Please do keep that thought in mind and decide what needs to change about it, and whether that change is what the 9th Amendment achieves, or if it achieves the opposite. In the resolution that was ratified by our membership on 13th July and subsequently forwarded to the Prime Minister, we called for, in part, the government to desist from taking any actions that offend the principle of separation of powers and our democratic institutions enshrined and entrenched in our Constitution. Again, see how the 9th Amendment answers our call, and then you make your conclusions. Remember that it's ultimately the responsibility of the people of Belize to make sure that government both hears and accedes to the will of the people. Thank you.
Thank you, Madam President. It gives me great pleasure to call to the podium Mrs. Jacqueline Marshallek, the President of the Bar Association.
Good evening, everybody. It gives me great pleasure to actually be here this evening. This is my first time, I guess, being present at the chamber and visiting with you here. So it's a really good privilege. It's a good thing, and I appreciate the mandate that Kay mentioned. And of course, for the Bar Association, we have our own mandate, which is to go out and to assist persons to help to understand any amendments, changes, any issues involving the laws of this country. So in keeping with that mandate, I think this is a very good initiative, and hopefully I'll do a decent enough presentation that you may have me back at some other time. We have under discussion this evening the Belize Constitution 9th Amendment Bill, and this bill is being taken very, very seriously by the Bar Association of Belize. The implications, as far as we are concerned, are huge for the way we are going to be governed and the capacity of government as it moves forward. There are some issues that are going to be raised as we go through this presentation, but at the end of the day, I'm hoping that I just give you sufficient information so that you have the knowledge that you need to process and make your own decisions as we go forward. So I have the bill essentially seeks to make amendments to two provisions of the Constitution. The bill proposes to amend the current Clause 2 of the Constitution and the current Clause 69 of the Constitution. The bill also proposes to add a brand new section to our Constitution, which is being called Part 13. And we will start this evening's presentation with a look at the proposed amendments to Clause 2. I think we have the screens up, and I think some of you also have copies of the bill as well. So Clause 2 of our Constitution, as it presently reads,
I think the people in the back are having a little difficulty.
Better?
Yeah.
Thanks. Section 2 is the Supreme Law Clause, and at present, Section 2 states that this Constitution is the supreme law of Belize, and if any other law is inconsistent with this Constitution, that other law shall, to the extent of the inconsistency, be void. The proposed change is to renumber the existing Section 2 as 2.1 and to add a new clause, which would be subsection 2. And the proposed amendment reads, the words other law occurring in subsection 1 above do not include a law to alter any of the provisions of this Constitution, which is passed by the National Assembly in conformity with Section 69 of the Constitution. We need to look at Section 69 to get the full picture and implications of what this amendment means, but for the time being, what you can see is that other law is now being presented or defined to exclude amendments to the Constitution. So whereas our courts have always sought to consider and review any amendment to any law, including amendments to our Constitution, to see whether those amendments are unconstitutional and whether or not there are any inconsistencies and should be void. When you add this new subsection, we'll no longer be able to look to see whether or not amendments to the Constitution are actually inconsistent with what we now know to be our Constitution. So it's essentially carving amendments to the Constitution out of the original Clause 2, and what you'll be left with is a situation where if there's going to be a review by the courts to see if a law is inconsistent, you will only be able to look at some lesser legislation, some sort of subsidiary acts or acts of parliament, but certainly no longer amendments to the Constitution. So the next provision that the government proposes to amend is Clause 69. Now, Clause 69 of the Constitution, you don't have it here, but Clause 69 is a section of the Constitution which sets out how the legislature is to go about making changes to the Constitution. If you want to change Schedule 2 of the Constitution or Section 69 itself, you need to have a 3/4 majority. You need to have a minimum waiting period between the tabling of the bill in the National Assembly and the second reading. If you are going to make a change to the fundamental rights and freedoms provisions, which we would call Part 2 of our Constitution, in addition to the 3/4 majority, in addition to the minimum 90-day period, you're also going to need a simple majority of the Senate to pass that amendment. In the event that you want to amend some other clause of the Constitution, you need a 2/3 majority to pass. but you will not need that minimum 90-day period. So there will be times when you will see constitutional amendments being tabled, but you're not going to get the 90-day minimum 90-day period between the tabling of the bill and the reading of that bill for the second time. So as you go through Section 69 as well, what it provides for is that a certificate will be presented by the Speaker of the House, and that certificate will essentially be definitive as to whether or not the procedure has been properly complied with. You also, of course, under Section 69 would require that the Governor General give his assent to the legislation that's been passed. So the proposed amendment is going to add a new subsection to Section 69. And that new subsection reads, "For the removal of doubts, it is hereby declared that the provisions of this section are all-inclusive and exhaustive, and there is no other limitation, whether substantive or procedural, on the power of the National Assembly to alter this Constitution, and a law passed by the National Assembly to alter any of the provisions of this Constitution, which is passed in conformity with this section, shall not be open to challenge in any court on any ground whatsoever." So the new Clause 9, it first seeks to state that the procedures set out in Section 69 are all-inclusive and exhaustive. So there's no other limitation on the capacity to amend the provisions of the Constitution. And second, a law passed in conformity with the procedures in Section 69 shall not be open to challenge in any court of law on any ground whatsoever. Now this is important because, as you know, if the government wants to amend the Constitution, they will know right from the start whether or not they have the capacity to do that. So they're going to go to the National Assembly knowing full well that they have the requisite 2/3 majority, 3/4 majority. So at the end of the day, the procedures in Section 69 will invariably be complied with. They will be able to move through Section 69 effectively without any issues. But what we have here now is a situation where they, having moved through those procedures, they can move through a procedure to amend the Constitution in a way which derogates from your fundamental rights and freedoms, flagrantly violates it, and you instinctively will say, you can't do that to me. I want to go to court. I want to challenge it. The thing is, you can still go to court and challenge it. But because of this provision, it means that when you get to court, the only thing that the court is going to be able to do is check to see whether or not the procedure set out in Section 69 has been complied with. Now, the reality of that is, if you know even before you file a claim that the certificate has been issued and the procedure has been complied with, there's really no point going to court. And an example I gave as well was, you have the freedom of expression. The government may pass legislation saying you have the freedom of expression, but no person can make any negative comment about the government of Belize. You will say, you can't tell me that. That abrogates my freedom. You want to go to court and you want to challenge it. In the past and at present, we can do that. Now, if you do that, you're going to get there and the court is going to say, I understand, but I'm very sorry. The only thing I can do is check to see whether the procedure was properly followed by the National Assembly. I cannot have regard to any content in this law. When you see the word substantive in there, it means that they can't have regard to the substance or content of what has actually been passed in the legislature. And at the end of the day, we are saying that if the National Assembly has this much power, what we're looking at is a situation where we're moving to parliamentary supremacy. Because in effect, they can go in and pass any law that they like about anything, and even if it's inconsistent, especially in relation to the Constitution, you will simply have that inconsistency sitting there along with the Constitution, and it just makes the whole thing very, very unworkable. You know, right now we simply wouldn't support that. You would want to go to court and challenge that. And when we talk about parliamentary supremacy, the position at present is that we do not have a parliamentary supremacy. We have constitutional supremacy. There are countries, like in England, they have parliamentary supremacy. Their laws emanate originally from what we know to be the monarchy. The monarchy passed those powers into their parliament, and it has remained that they continue to have that kind of power. But here in Belize and in other Commonwealth countries, we have written constitutions. In England, they don't have a written constitution. We have written constitutions. And our written constitution in Belize has Section 68. And Section 68 says that subject to the provisions of this Constitution, the National Assembly may make laws for the peace, order, and good government of Belize. I'll read it again. It says, subject to the provisions of this Constitution, the National Assembly may make laws for the peace, order, and good government of Belize. So it's the Constitution that establishes the legislature. It's the Constitution that gives the power to the legislature to make our laws. And we have the Constitution saying that the lawmaking powers are also subject to our Constitution. So we also have this principle of judicial review. And the principle of judicial review was developed in the United States, which has a constitution very similar to ours, where you have a distinct legislature, executive, and judiciary. And the principle developed in intending to check the power of the state to pass certain laws that they consider to be unconstitutional. So you'll hear about a case called Marbury against Madison, which is an 1803 case. You'll hear that case tossed around. And basically, the Supreme Court of the United States held that an act of Congress was actually unconstitutional. And so from there, we have developed, and all of the courts have followed, to exercise this right of judicial review, the right to actually review legislation to see whether or not it's unconstitutional. In our Constitution, we also have Section 20. Section 20 says that if any person alleges that any of the provisions of Section 3 to 19, inclusive of this Constitution, has been, is being, or is likely to be contravened in relation to him, then without prejudice to any other action with respect to the same matter which is lawfully available, that person or other person may apply to the Supreme Court for redress. And Section 22B then goes on to say that if you go to court and you ask them to look and consider and see whether or not your constitutional right has been infringed, the court has the power to make such declarations, orders, issue such writs, give such directions as it may consider appropriate for the purpose of enforcing or securing the enforcement of your rights. So we have at present, because of our Constitution, the right of judicial review, and we have the ability to go to court to ask the court to protect our rights from any derogation or abrogation. We have also in the Caribbean, there is a considerable amount of case law, like Collymore and the Attorney General, where the courts have exercised this power and affirmed that the role of the judiciary is to be the guardian of the Constitution. That is their functional role, along with interpreting the laws of Belize. And it is a role that the former Chief Justice Abdoulaye Conte affirmed in the case of Barry M. Bowen and the landowners against the Attorney General. And you're going to hear a lot about that case as the weeks go on. So I want to just tell you a little bit about it. And essentially, the Supreme Court was asked to consider whether or not Clause 2 of the Belize, Section 2 of the Belize Constitution, it's Clause 2 of the Belize Constitution 6th Amendment Bill, which sought to deny persons access to the Supreme Court. The court was being asked to consider whether or not that particular clause would be unconstitutional. And it's important to note that the issue was really the denial of access to the courts. It was not about who was going to own the oil and minerals and petroleum. The landowners and Mr. Bowen never challenged the fact that government was actually going to be acquiring through the bill the oil, petroleum, and minerals. And that was because even though it had not been in the Constitution before, there was actually an act which actually said that these things belong to the government of Belize in any event. So they looked on it from the position that, well, it was in an act before and now they're putting it in the Constitution. I don't really want to fight about that. But this provision, it says that I can't go to court to have the court consider what interest, if any, I may have in all of this. No, I want to challenge that particular provision. So the Chief Justice in that case, he carried out what he called an audit. And this audit involved him looking at the provisions of that bill against what was contained in the Constitution and trying to determine whether or not what was in that bill held up or was in conformity with what was in our Constitution. And what he held is that the enactment of Clause 2, as it stood, would have infringed the preamble of our Constitution, because the preamble specifically recognized our rights to property. He recognized that he declared that it infringed Section 3 of our Constitution. We have a right against the arbitrary deprivation of property. He said it would also infringe Section 6 of the Constitution. Section 6 of the Constitution is a section that says we have equal protection before the law, and that has always been interpreted to include access to our courts. He found that it would infringe Section 17 as well. And then he, of course, ordered that that particular aspect of the bill be declared unconstitutional. Now, he said in that case that Clause 2 would, I quote, upset the basic structure of the Constitution of Belize regarding the principle of the separation of powers and its concomitant, the rule of law, and the protection of the fundamental rights, especially those relating to ownership and protection of property from arbitrary deprivation. So we then got into a situation where the government appealed the Bowen decision to the Court of Appeal. But what happened at the level of the Court of Appeal is that the government had an affidavit prepared by the Speaker of the House, which indicated that government would move forward with the passage of the bill, but without the offending section. So they indicated to the court that they would not be continuing with the intent to pass the bill inclusive of that section, that Clause 2, sorry. So the Court of Appeal said, well, if you're not going to pass it, what you're asking me about, there's nothing really here to talk about. This is all academic. And the case was dismissed. And the effect of that is that the Bowen case is still good law for Belize. Now, Section 20 also says that if any person is aggrieved by the decision of the Supreme Court, you can appeal that decision to the Court of Appeal. And it was before the Court of Appeal. And it was open to the government if they felt very strongly about the arguments that they put forward in that case, to have the court consider it. But they didn't do it. They decided they would simply remove the offending section. So the decision of the Chief Justice is actually still good law for Belize. With that in mind, I think something that concerns us at the Bar Association is that it's really not open to us or the Prime Minister to say that the Chief Justice was wrong. What we can say is that we don't agree with him. We don't agree somehow with the decisions or the considerations and in the end the decision. But we can't say he's wrong. It is the law of Belize and we're all expected to respect it. And we have also a lot of discussion going on about whether or not the Chief Justice, he started wanting to make law and he thought himself capable of making new law. But as you read that case, you realize that the Chief Justice was at pains to make it clear that he was fully supportive of the principle of separation of powers. He said when it comes to the policy of what government wanted to do with their oil and minerals, that was not something that concerned him any at all. That's their purview. In relation to legislation, he said, I quote, "Lawmaking is, of course, the preserve of the legislature, but it is to the judiciary that the responsibility falls to determine any challenge to that law, be it ordinary legislation or a proposed constitutional amendment. It is this responsibility that solely concerns this court and nothing else." So he was fully aware as he made this decision that it is to the legislature that the task falls to make legislation, and it falls to him to interpret and to review that law. And in that case, the government argued exactly what is now being proposed, that Section 69 is the only limitation on the lawmaking powers of the National Assembly. In that case, it's a very interesting transcript, because what came out in that case is the claimant said, but my lord, if we follow along that line, government could actually walk into the National Assembly and decide to cede Belize to Guatemala, and we wouldn't be able to say anything about it. And so the Chief Justice put that question to Mrs. Lois Young Barrow, to which she responded that yes, it would be possible. Section 1 of the Constitution is not an entrenched provision, so if government decided that they wanted to pass that legislation, then they could do it. And as long as they had complied with Section 69, it's done, it's over, and it's none of the court's business. And then he also put to her the issue of revoking the Constitution. And she said, you know, it's a very difficult thing to accept in 2008 that the National Assembly can revoke a constitution. But that's the way it is. They have that power. And you do not have the authority to say to us that we can't do it. And what the Chief Justice is saying, I am saying to you that you can't do it. And I'm saying to you, you can't do it because there is this doctrine called the Basic Structure Doctrine. And it's a principle and a doctrine that was originally developed in India. So you're going to hear case names like Kasafanandra, and sometimes I have difficulty pronouncing some of them. But it has been developed in India, Mauritius, Bangladesh, and certainly in a number of countries where we've had this issue creep up of governments wanting to move to actually prevent courts, get rid of the judiciary, and the courts have had to step in and say, hold on, let's take a look at this. And what the basic doctrine essentially says is that in determining challenges to amendments to the Constitution, especially those which were infringing on fundamental rights and freedoms, you have to look at the entire structure of the Constitution. And when you do that, the structure must be maintained. So you can revoke all of the provisions that relate to the judiciary, but you cannot revoke the establishment or the requirement that there be a judiciary. It makes a nonsense of the Constitution if you walk in and say, we're no longer going to have a judiciary. There are certain things that must remain. And in this particular case, one of the things that he said must remain must be the preamble of our Constitution, so that you can go ahead and revoke all of what you want, but when you bring it back, make sure that what you bring back recognizes all of the things in our Constitution that the people of Belize affirmed that they wanted represented in that document. So if you have some time, you should look at the preamble of your Constitution, to see what it says. It affirms so many different things. You have it up there? You know, it gives an idea, for example, whereas the people of Belize affirm that the nation of Belize shall be founded upon principles which acknowledge the supremacy of God, faith in human rights and fundamental freedoms, the position of the family in a society of free men and institutions, the dignity of the human person, and the equal and inalienable rights with which all members of the human family are endowed by their Creator. And it goes on to recognize property rights. It says the things that we believe as a people. So what he's saying is that the preamble of our Constitution, government argued in that case that the preamble of the Constitution can only be an interpretational tool that can be used to figure out what the provisions in the Constitution were intending to do. But what the Chief Justice said is that the preamble actually has legal effect and it must be respected. So when you go through your exercise thinking that you have all of these wonderful powers, just keep in mind that you must maintain the basic structure of the Constitution and you must have regard to the preamble of the Constitution. So essentially, that's the Bowen case and some of the issues raised. The case also touches on issues, as we had Kay mentioned, separation of powers, of course, rule of law. The rule of law doctrine essentially developed as a way to curb the excesses of the state. Originated with a gentleman we call Albert Dicey back in about 1885. And it's both a constitutional principle and it's also an institutional or political philosophy that seeks to basically treat with how we should be treated or interact with government. So in the institutional sense, it conveys the idea of government not under men, but under laws. And it contemplates a civil society under equal and just laws. In the constitutional sense, it protects the citizen's rights to legal certainty in respect to interference with his liberties. It guarantees access to justice and ensures procedural fairness in relation to administrative decision-making by the state. So some of the tenets that you have under your rule of law would be that government must act within its powers. Government cannot act outside the scope of its powers. So in that Bowen case, government is saying your powers are limited by the Constitution. They're subject to what is in here, and you must exercise it for the peace, order, and good government of the people. Any law doesn't meet that requirement, there's a problem. It also says nobody should be punished except under a specific law for breach of a specific law. So government can't just pick us up off the street and say, you know, that's it, I feel like punishing you. If they can't find a specific provision in a law that says you are to be punished, no, it doesn't work that way. Rule of law also says every person, irrespective of their rank, is subject to the laws of the country. So from the Prime Minister right down to the littlest man on the street, we're all have to be subject to the laws of the country. State power has to be specified. And of course, for officials, they have responsibilities and they shouldn't act without legal justification. So those are some of the concepts that came into play in that case. So with all of that, we haven't even gotten to the nationalization part yet. So let's look at the new part 13. So part 13 is where government actually moves toward trying to treat with this issue of assuming majority interest in certain public utilities. And it adds in some new sections, 143 to 145. And we have up here first the definitions of public utilities. It means the provision of electricity, telecommunications, and water services. Public utility provider is specifically defined. We're only treating in this particular section with BEL, with Belize Telemedia, and with Belize Water Services Limited. It says, however, if you go down just a little bit further, that any other entity designated as a public utility provider for the purposes of this part by a resolution passed by the National Assembly in that behalf. And that means that there is the potential for government to add other companies to this list as it now stands, provided that they pass a resolution in the House. You just go down a little bit more. We get into the definitions for majority ownership and control. So it means the holding of not less than 51% of the issued share capital of the public utility provider, together with a majority in the board of directors, and the absence of any veto power or other special rights given to a minority shareholder, which would inhibit the government from administering the affairs of the public utility provider freely and without restriction. So it means that government must hold not less than 51%. They can certainly hold more, but they can't have less than the 51%. And then we come down to 144, which says that government shall have and maintain at all times majority ownership and control of a public utility provider, and any alienation of the government shareholding or other rights, whether voluntary or involuntary, which may derogate from government's majority ownership and control of a public utility provider, shall be wholly void and of no effect, notwithstanding anything contained in Section 20 or any other provision of this Constitution or any other law or rule of practice. So government really is obliged to hold on to that 51%. If they seek to transfer any of that out, then it's going to be deemed essentially to be void. So then we go down and we have a little provision here that says that in the event, we saw with the government shareholding that the shares of Social Security are gonna be a part of their 51% at any given time. So if Social Security wants to sell any of their shares, they have to first offer for sale to the government, and the government shall purchase from the board so much of the shareholding that's necessary to maintain the 51%. And of course, there's a neat little provision at the end that says, and every such sale to the government shall be valid and effectual for all purposes. I'm going to just run through it so we have an idea of the overall scheme, and then I'm going to come back and treat with some of these issues. Any alienation or transfer of the government shareholding contrary to subsection 1 above shall vest no rights in the transferee or any other person other than the return of the purchase price if paid. So Social Security decided, these are my shares and I'm going to sell them to Kay because Kay offered me a lot of money, then that's not going to work. No rights are going to vest in the shares that Kay would purportedly try to take off of them. But she can get her money back, essentially, from Social Security. So we go down to 145. It says, for the removal of doubts, it is hereby declared that the acquisition of certain property by the government under the terms of the Electricity Act as amended and the Electricity Assumption of Control over Belize Electricity Limited Order 2011, which is the Electricity Acquisition Order, and of course the Belize Telemedia Acquisition Orders. Those will be deemed to have been duly carried out for a public purpose in accordance with the laws authorizing the acquisition of such property, and no court shall inquire into the constitutionality, legality, or validity of the said acquisitions, notwithstanding anything to the contrary contained in Section 17, Section 20, or any other provision of this Constitution, or any other law or rule of practice. So we essentially have the legislation saying that the court really doesn't have the right to inquire about very much in relation to the acquisition. And then the next subsection makes it clear that what we're looking at here is a bar on the jurisdiction of the court. So it says that the bar to the jurisdiction of the court contained in subsection 1 above is absolute, and no court shall assume jurisdiction on any ground whatsoever, including without limitation any alleged ground or lack of jurisdiction in the persons making the said acquisition orders, or any ground alleging breach of the rules of natural justice. So we have one final provision in the general scheme of how this is supposed to work, and it's 145. Sorry, you have 3, which is saying that it'll be deemed the shares, the acquisition orders for telemedia and BEL, these shall be deemed, that the property shall be deemed to vest absolutely and continuously in the government, free of all encumbrances, with effect from the date of commencement specified in the said orders. You might remember too that in those orders, what government did is retrospectively acquire those companies. So even though you're treating here with the wording of the second acquisition acts, those acts actually specify that the dates of acquisition take effect from the very first acquisition. So essentially what we're treating with here is retrospectivity all the way back to the first acquisition. And nothing in the foregoing provisions of this section shall prejudice the right of any person claiming an interest in or right over the property acquired under the said acquisition orders to receive reasonable compensation within a reasonable time in accordance with the law authorizing acquisition of such property. So that's basically the scheme of how government wants to treat with the vesting of the majority interest in the telecoms companies. One of the things well, I think we start from the position, certainly from the Bar Association for our members. We decided that in relation to the acquisition itself, we really would not treat with that. With the first acquisition, certainly there were concerns, but the parties were in court. So we figured that we're not really needed there, they will work through it. The second acquisition as well, we didn't make any statement there. But we did have concerns about what happened in terms of how the Court of Appeal decision was treated with. But certainly now we come to the 9th Amendment Bill, and we have very real concerns, but we're still not taking issue with the actual decision or policy by government to acquire or to vest the 51%. We have decided we will leave that with our members essentially to treat with whether or not they actually support government or not. Government says they have the majority. They think that this is the will of the people. Of course, our concern there is how do you determine what is the will of the people? You know, we have in relation to offshore drilling, Oceana has been told, well, you need to go get you need to trigger a referendum and you need 17,000 signatures, but it isn't everything that's being treated in that way. And certainly in relation to the acquisitions, the bar wasn't consulted. I don't know that if the chamber was consulted. So it's, you know, we're a little like, okay, the will of the people, we're not too sure, but you say you're good and you have the majority. So we'll leave that to you. But then the concerns start for us with SSB. And the concern for us with SSB is that shares are private property. SSB is a statutory board which is separate from the government of Belize. We don't know whether or not SSB was consulted as to whether or not they want their shares to be treated with in this way. But there is the potential here, if SSB doesn't agree with it, or if this legislation goes through in its current form, that there is the potential for conflict. Why is that? Government, if SSB wants to sell its shares, they have to first offer it to government. So suppose SSB gets an offer from somebody for $15 a share, cash, I put in your account next week if you want it. Government says to SSB, can't give you $15 a share, can give you $7 a share. Payable part cash, dividends, bonds over a certain period of time. for example, Social Security votes and says, well, we're going to help government out and we just sell them the shares at that particular rate. People are going to have concerns about that because they're going to think, well, why not take the cash up front, and is that really a good investment decision? But the reality is, if they decide to treat it in that way, and for some reason SSB has to take a deal from government that we don't necessarily think is the best deal, you have this little wording at the end that says, and every such sale to the government shall be valid and effectual for all purposes. So that's just how it is. But at the end of the day, Social Security will have to decide whether or not they want their shares to be linked in this way with government, because shares are private property and shares are an asset and they have value. So in putting it in here, there are some limitations that SSB will have to treat with. The other concern that we have is the section which vests the majority ownership and control in the government in BEL and telemedia from the original date of the acquisition, because it's saying that with respect to those acquisitions, they will be deemed to have been for a public purpose. That's the first thing. Remember that under Section 17, if something hasn't, if your property has been acquired and it isn't for a valid public purpose, then the courts can declare that taking invalid. And that's what happened with the first acquisition. Government said your public purpose was invalid. So government now has passed a new acquisition act with new public purposes, but we're saying here that the court really won't get a chance to look to say whether or not the public purpose in the second acquisition act is actually a valid public purpose. It's being deemed here to be a valid public purpose. And the other thing, of course, is that the wording makes the acquisitions retrospective for the first acquisition. And don't forget that we had a decision of the Court of Appeal on the first Acquisition Act, which said that that acquisition was void and of absolutely no effect. So how is it that we have a Court of Appeal decision that said that your first acquisition was void and of no effect, but you come into the Constitution now and say, I don't really care that the court said it was void and no effect. I'm saying in the Constitution that it's perfectly valid from the very first taking. And what you do when you do that is you effectively overrule what the Court of Appeals said. And for the Bar Association, that's a concern, because the decision of the legislature to overrule the Court of Appeal, you're exercising what is a judicial function. You are the legislature. You get to make the laws. There is a judiciary. They get to check to make sure the laws are constitutional. So you don't get to come into the Constitution and say what is valid and what is legal. The Court of Appeal already said that the first acquisition was void and of no effect. It was illegal. So why are we coming into the Constitution now trying to say that it's legal from the first? You can take it now and you can say it effectively vests from your last acquisition, but the idea that you can dismiss what the Court of Appeal ruled in this manner is not something that we agree with. We think it's in violation of the separation of powers, and it's an assumption of judicial function. So that's a big concern for us. We also have, of course, the lovely provision that says that no court shall inquire into the constitutionality, legality, and validity of the said acquisitions. And, you know, that's a very real concern, because I should read it a little more. It says, for the removal of doubts, it is hereby declared the acquisition of certain property under those two acts was duly carried out for a public purpose in accordance with the laws authorizing the acquisition of such property, and no court shall inquire into the constitutionality, legality, validity of the said acquisitions, notwithstanding anything to the contrary contained in Section 17, Section 20, or any other provision of this Constitution, or any other rule or practice. Why is that a problem? Remember, we said that Section 17 is a provision in the Fundamental Rights and Freedoms that says that you have the protection of your property from in the event of an acquisition, you have certain rights which will include compensation. Section 20 is a provision that says if you believe your rights have been infringed, you can go to the court and ask for the court to review what has been done, and there is the opportunity for redress. So, notwithstanding when you would have gone to court, court would have been able to consider all of what has been done to you. Now this particular section is saying, well, Section 17, Section 20, those don't apply here, and the court doesn't get to look into the constitutionality, legality, or validity of the acquisitions, period. So if you're saying that here, there's really no point to going to court again. The court is not going to be able to do anything. And since this section also stands as an amendment to the Constitution, the provisions that we looked at earlier to 2 and 69 mean additionally that all the court could do anyway is look to see whether this has been passed in accordance with Section 69. And we're saying that, you shouldn't treat with people's rights in this way. We understand that there's an issue with Fortis, we understand there's an issue with telemedia, but it doesn't matter to us who it is, and if you don't like the person or there's issues or what have you. We are minded to say everybody needs to have the right to go to court and to be able to have a court look into whether or not what legislation has been passed, whether or not it infringes their constitutional rights. When you go to court, there's no guarantee that the court's going to find that your constitutional rights have been infringed. They may well not have been infringed. And you can lose rights by constitutional amendments if it's in the interest of the public and good government and peace and order. So this is why you hear amendments like being proposed, like the preventative detention, because it will be proposed that at the end of the day, yes, your liberty might be deprived, but you would give up that liberty in the interest of having a safer country. So there are provisions and there are ways to amend. Certainly even that would have been possible for, or possibly open to challenge. But we're saying let people be able to go to court, respect their right to go to court. Do not try and put these kinds of fetters on our courts. Our courts need to be able, if they're going to be the guardians of the Constitution, if they're going to be able to effectively decide whether or not somebody's rights have been violated, then they need to be able to look at what's inside the legislation, and they shouldn't be told what they can consider and what they can't consider. And no, it doesn't work that way. So for us, this particular section, those are the primary concerns. The last section, which speaks to compensation, isn't really a problem here, or a serious problem, because it's repeating the wording in Section 17, the right to reasonable compensation. The only problems we have is that in the acquisition acts themselves, government tried to actually say how compensation was to be calculated. That in and of itself was previously a judicial function. And it's something we're not encouraging them in this particular situation. You don't want a situation where if our rights to property, say government has to take any of our property for any reason, and I use the example, they want to build a cruise ship terminal in Placencia or St. Vite. So they look at this project and they say, we need to acquire some land to be able to do this project. And they look and say, oh, but if we have to acquire all of this beachfront land and this property, this is going to be very expensive for us to do. So why don't we write into the Constitution that beachfront land is to be compensated at $20 an acre? Well, the first thing we would want to do is run to court and say, Mr. Justice, sir, my property is not worth $20 an acre, and that cannot possibly be reasonable consideration, be reasonable compensation, as the Constitution says I should have. But the reality is when we get to court, the court's going to say, well, if the National Assembly says it's worth $20 an acre, Let's just check and see if Section 69 has been complied with. And I understand why you're concerned, but I really can't help you because Section 69 has been complied with. You don't want government, the ability to to calculate compensation has always been something that the courts do, not the legislature. So, you know, the only issue is when you're treating with all of this as one package of legislation is that there are some issues for the owners as to how that compensation is actually going to be calculated at the end of the day. So we would prefer that the function of calculating how much people are to be compensated for their property effectively remain with the court without any fetters. And that's essentially that. So, in a nutshell, that's the Belize Constitution 9th Amendment Bill. We have heard the government come forward and say that, especially in relation to Section 2 and in relation to Section 69, it is merely a clarification of what the law has always been. And that is something that the Bar Association, disagrees with. It is a radical change for us. Because as we sit in this room, if any amendment is made to any law in this country, including an amendment to the Constitution, all of us can go to a court and all of us can ask the court to look at that legislation. And the court can look at not only the procedure to see whether or not the procedure has been followed, but the court can also look at the content to see whether the content actually infringes our constitutional rights. What we have here now is a move when this legislation is passed where the situation is you go to court and the court is only going to be able to see or check whether or not the procedural requirements required to change the law have been followed. And as I said before, since government more than likely would have had their 2/3 majority, waited their 90-day period if it was necessary and all these other things in Section 69, there is really not going to be any point to you going to court because the court can't look at anything. The court can't look at the content. The court may be sympathetic to you, but the court really won't be able to assist. Their powers are effectively limited by Section 69. And so for us, that is a radical change. That's a fundamental change. The response of the government has been that, you know, if you don't like it, you know, we're not going to pass legislation that we think the people are going to vote us out for or that they won't like. But for us, the reality is that you're asking us to trust you. And the reality is we don't. And even if we did, we don't know if in the event that you are voted out for some reason and another government administration is put in place, are we supposed to trust them too? We don't need to have this much power concentrated in any one section of the government without the power to check it. And it is a very, very real concern for us. So we're saying at the end of the day that, you know, this is a radical change. The concept that the National Assembly can walk into Parliament on any day and change any part of your constitution, and you cannot go to a court and ask the court to look at the content of that change, is something that is very, very different to what we know now. And it's certainly very different to what the Chief Justice did in the Barry Bowen case. And even for us, even if we were to get into our legal arguments and cases and different countries and what have you, as a people, we have to ask ourselves, do we really want to go this way? The Chief Justice, at the end of the day, what he did in the Barry Bowen case was recognize somebody's right of access to the courts. He had reasons for how he got there, but at the end of the day, what he did was defend our constitutional rights. So, do we really want to, having moved that far forward in terms of the protection of our rights, where the court has actually said our preamble has legal effect, do we want to go to the point now where we say that the courts don't have any authority to consider these types of issues? And I'm going to leave you with a quote from the Chief Justice in the Barry Bowen case. He says, the government was arguing the same point about parliamentary supremacy in Section 69. He says, I therefore find myself unable to accede to the defendant's arguments and submissions that Clause 2 would be a valid exercise of the power to alter the Constitution as granted to the legislature, so long as the provisions of Section 69 of the Constitution are satisfied. I find this position to be contrary to the basic structure of the Constitution. The hallmark of this position is that in the face of the requisite majority in the legislature, 3/4 of its membership in the case of the fundamental rights provisions in Part 2, no provision is beyond alteration or revocation. In my view, on this hypothesis, the guarantee of fundamental rights and freedoms assured in Part 2 would only be a paper guarantee, and that any of those rights and freedoms may, in the hands of the requisite majority in the legislature, likely disappear by the process of alteration. I find that it is no answer to say that this is unlikely. This case itself disproves that facile answer. And essentially what he's saying is that, you go down that road, your rights aren't really worth the paper that they're written on. So thank you very much.
Thank you, Mrs. Marshallek. I will now call on Senator Godwin Holtz. He will be conducting the question and answer segment.
Thank you very much, Ms. Kim. I want to thank Mrs. Marshallek for that excellent review of the proposed amendments to the Constitution, the 9th Amendment. Just before we begin, for those of you who saw what was termed a debate last night on Love FM, ran for 4 hours, I thought that you either came away with a little bit more clarity or more confusion. It was a very good exercise. I trust the next time we do it, and I hope we do another one, we'll have a little more, a less stiff approach to it. There are some things that I think you really need to be clear on, and Mrs. Marshallek pointed them out, but perhaps they flew over your head. In the practice of making law, and I see former Minister Joe Coy here, who's been in the legislature for a long time, those of us who are in there like myself for 8 years know that the practice is very different from the theory. Very different from the theory. For example, there is no provision that requires the National Assembly proceedings to be broadcasted. So, there's nothing to say it will not be at any time. In fact, there are many times there are Senate sittings and it's not broadcasted. In fact, the first time the Senate was broadcasted was courtesy of the chamber who paid for it, and sometimes when I paid for it. So, that is no guarantee. There is a provision in Section 69 which you must not miss. Because last night you'd have heard the minister said, oh, this cannot happen. We have to wait 90 days. And people will demonstrate, etc. The fact of the matter is you do not have to wait 90 days. If you are not amending any of the sections that fall under Schedule 2. If you're amending sections that do not fall under Schedule 2, you don't have to wait 90 days. You can do it in 1 day. You can call a meeting at 9 in the morning, like we did BL and BTL, present the bill, have its 3 readings, call the Senate at 2 o'clock in the afternoon, present the bill, and it's done. I don't see anything that stops that from happening. I could give you 3 examples. I cited 2 last night, which again, perhaps in the whole debate, people missed. Section 27, which deals with dual nationality, does not fall under Schedule 2. So that could be amended in 1 day. Section 112 to 113, which deals with pensions, could be amended in 1 day. And so be it. You would find, and those are fundamental rights, even though they don't come under the fundamental rights section, you will say, I worked all my life, I'm entitled to my pension, these things are protected in the Constitution, and you find it's whipped out. What will the court say to you? I'm sorry for you. Or you could find you had dual nationality and you set up your life around those, and you find from 1 day to the next, not so. And then what will the government say? Oh, we have people support. The people are against this. People don't want those people getting all those big pensions, or people don't want everybody here to have dual nationality. But there's an even more interesting one, which I've mentioned exactly 9 times already on the show that Senator Gardner and myself have been doing for 2 years on the Constitution. And for those of you who have a copy, Go to Schedule 1, which defines our territory. That's not Schedule 2, you know, that's Schedule 1. That takes 2/3 to amend it. And here's a neat little thing I could pull on you and you would never know. If you look in Section 2 of Schedule 1, it says, Schedule 1 talks about our territory and it describes it, and the area, and it describes all the keys, etc. And Schedule 2 says, the area referred to in paragraph 1 of this schedule includes, but is not limited to. And it puts all the keys that it includes. That falls under a 2/3 majority to amend. If I chose to appease Guatemala and I said, you know, there are a little bit of territory there which is not described here, and I simply said the area referred to in paragraph of this schedule includes Ambergiski, etc., and takes out but is not limited to, I have a change in that section. That can be done with 2/3 majority, could be done in a day. So, don't tell me that you need to be on the street, that people are going to be up in arms. You would never even know it happened. Or you may know it happened and it flew right over your head because you never read the document clearly. You know how many pieces of legislation I've seen like that already? So, one of the things we need to secure, as Mrs. Marshall said, and the other myth is there is no, unless somebody convinced me to the contrary, no separation of powers between the executive and the legislative in this country. None. Doesn't happen. The executive in this country, for the most part, has always controlled the legislature. They have the majority in the House of Representatives, 16 out of 31, do the math. That's the cabinet acts collective, and they appoint the Senate, and the Senate sings with one voice. In fact, the Senate now sings even more with one voice. You don't even hear any debate. So, and it goes to the Governor General who signs. So there's no separation there. The only separation has been the judiciary. Well-established separation. So legislature and executive is one, judiciary is separate. We run to court for anything. And when you begin to say you can't go to court, and the third myth is, and you heard it last night, you can go to court, man. You can go to court. Please, why are we being disingenuous? Mrs. Marshall, it's clear. Yes, you can go to court. It means you can physically walk in the building up the steps and get something before a judge. And he says, well, I'm sorry for you. That's why I asked a specific question. If I went to court, is there any chance that this would pass? And Mr. Ellington, Honorable Senator Ellington said, no. So what's the point in going to court? Why did you fool me, man? Yes, I can go to court. So please let not have the people silly about, oh, we could go to court, you know. This is simpleness, man. I don't like that, you know, be straight. I can go to court, yes, I can walk in the building, I can file my things, pay my money to a lawyer, and I will lose. That's not going to court. Going to court is the anticipation that there's something that can happen. It is just like the provision in the Constitution that says any money bill goes to the Senate can't do anything about. Now why the hell you're bringing resolutions and bills and those money bills to the Senate? You ever see me vote on them? First time I abstained, the whole nation went ballistic. I never voted on any of them because it's foolish, stupid, ignorant, and wasting my time. Please. We're in a real world doing practical things, trying to get ahead and trying to make a good. Take those nonsense out. So don't tell me I could go to court and nothing will happen. Because then I can't go to court, okay? Don't tell me I can demonstrate on the street when you'll have media and party-supported media drumming up and all the spin that's done and people are confused and you can't, and you're fighting up among yourselves. That's not demonstration. Don't tell me you consult with people when there's no mechanism to consult with people. And if you even had the mechanism, which is the referendum, it's only to solicit views. And you have a referendum act which says if 60% don't turn out, it's void. Yet you have a whole entire National Assembly that is elected only and 54% of the vote, all 31, do the numbers. But yet, if you have a referendum, 60% have to go out there. And then the half plus one would carry the day. So if you had 59.5% going out there and all said no to something, it was void because you never get the 60%. These are games, man. And don't tell me you can recall any elected representative. Just look at that piece of legislation too. They're all plain rubbish, you know. On that note, that's my view. I open the floor to questions, please. Ah, yes, Ben.
Question. Okay. What is different about the prohibition in this proposed 9th Amendment versus the other prohibitions that exist within the Constitution?
You mean the prohibitions, the ouster clauses that we were talking about last night?
Yeah, about questioning matters in the Constitution in a court of law, putting it outside of the realms of the court.
Most of the ouster clauses that you see in the Constitution have to do with procedural issues, not issues relating to substantive fundamental rights. You see ouster clauses, for example, right there in 69, where it's saying that if the Speaker of the House gives his certificate that these things have been complied with, then the court shall not inquire into that. If the Governor General has to do certain things, then they'll inquire into that. And it's simply easier to have these things documented and have a court, have these people issue these certificates to say that these things have been done or not done. The difficulty we have with what government was saying at the debate last night, or the representative, the Solicitor General was saying, is that, well, you have ouster clauses in the Constitution already, so when you're making a fuss about this now, it doesn't work that way, because those ouster clauses generally relate to procedural matters and not to issues as to whether or not your fundamental rights and freedoms have been affected. And the courts have made it very, very clear in relation to any of those ouster clauses. If I find strong and compelling reasons why I should look beyond that ouster clause and check to see what the Governor General did, check to see if the Speaker improperly issued that certificate. So suppose somebody files an affidavit saying that, Mr. Speaker, on that day, I could tell you for a fact, these 10 representatives weren't there, so to speak, so that the requisite majority wasn't there. You may find, depending on just who gives that affidavit, that the court says, there's something suspicious here. I need to look behind it and just do a double check. So right up through to the Privy Council, those ouster clauses have never been upheld where you have excesses in jurisdiction or somebody's constitutional rights being infringed.
Questions? Can't be all that clear, man, please.
Jackie, at the same token, can we challenge, or maybe the bar or anybody could challenge this draft amendment, or when it becomes law, the ouster clause that it's unconstitutional?
The Bar Association, we're currently doing our research to decide if we will challenge and when we will actually do the challenge. The only complication with the challenge for us, in the normal course, we just jump up and do it. In the normal course, we always meet with this whole issue of the separation of powers. Because the legislature is the one who gets to pass the laws, the judiciary is never very quick to interfere with that lawmaking power. And you have had cases where they've said, well, the legislature has the right to make these laws, so they should at least have an opportunity to go into the House and debate, and I shouldn't stop them from going through the paces of what they have to do. Bring it to me after it's passed, and then I will look at it. But we have a case out of the Bahamas, which is the Bahamas Methodist case, which actually says that in some limited circumstances, you can actually get the court to intervene before the law is passed. And one of those limited cases would be where if the law is passed, I won't have the ability to treat with it. And I think this might be a classic case of that, because if the law is passed, then when I want to challenge it, the law will be reading that the jurisdiction of the court has been reduced to only considering Section 69. So at this particular point, it is very likely that we will challenge it. Interestingly enough, I've taken calls from 2 people offering themselves to be claimants if the bar wishes to challenge it. We have a little difficulty right now in that a lot of the members are traveling out of the country or taking vacations, but certainly the next available meeting that we can get everybody together, that's going to be the decision that we have to take.
Questions? Antonio?
Yes, good evening. Under the proposal section 13. And you mentioned it between the differences and the different entities between Social Security Board and the government. But under the interpretation, it has that government shareholding shall be deemed to include any shares held by Social Security Board. And provided that in the event the Social Security Board will intend to sell part result in the government shareholding, that means that the government will have the first preference to purchase the shares of Social Security Board. How do they combine the government shareholding under one entity, under the heading government shareholding, when they are two separate entities?
Well, that's a very good question, which is why I say I don't know if anybody had a conversation with Social Security. Certainly, Social Security hasn't made any statement to the public as to whether or not they agree to have their shares treated with in this way and to be included in the scheme in this way. Because it's quite possible for government to have the 51% and have the 51% made up of their own shares. But they have, I can only assume that money issues make it easier to say, let's just include what we have already bought through Social Security in our 51%, then we won't have to spend to acquire, enough of what government would hold on its own to reach 51%. But the reality is that I don't know how Social Security will treat with this issue, but they certainly have issues to consider because their property is being, I should say their ability to treat with their property in the way that they would normally have been able to treat with it is going to be very different if this passes as it currently stands. So they'll have to think about it. I would like to hope that they would think about it. There are some things we can kid ourselves about, pretend if we want to. But the way Social Security is structured right now, we know how that entity operates. And if government has decided that they want to be able to use government shares in this way, in the same way they got to acquire or the purchase of the Social Security shares went through in the first place, I don't doubt that they might be able to secure the ability to say, this is exactly how Social Security is okay with this arrangement then. But at the end of the day, all we're saying as a bar association is you are actually limiting the property rights of Social Security by insisting that they come in and be a part of your 51% and insisting that you have the first option and that really at the end of the day it must be sold to you. So Social Security has something that they have to think about.
The next question is this. And it says that no court shall inquire into the constitutionality, legality, or validity of the said acquisitions. And under 4, it says nothing foregoing provision of this section shall prejudice the right of any person claiming an interest in the right or what property of said acquisition others. Now, if the people and persons involved in both the telemedia and BL are not satisfied with the terms of the payments from government, but you also mentioned that the acquisition orders contain certain sections whereby the government had decided how to pay the compensation. Would these people have the right to challenge those payments and in the court?
Well, at the moment, they certainly would have the right to challenge any issue in relation to how that compensation is structured. I don't know the details of the case to know exactly what they've decided to do, but if they have any issues or concerns with how this whole acquisition has been treated with, then they can go to court and ask the questions about it. But at this particular point, I think what they're really effectively trying to do is say, I'll allow you to talk about compensation, but I'm not going to allow you to talk about any other issues, just compensation. An interesting point to note about 4, though, is that, remember I had mentioned that it's possible to add other companies to this Part 13. Well, Section 4 is very specific to compensation in relation to Belize Telemedia and Belize Electricity Limited. So if we add somebody else to that list, this little provision here about compensation actually won't apply to the new entity that's been added.
Yes, I have a question. Can the government, after October 21st, which is the 91st day of this particular bill, can the government therefore, after this, reintroduce the 8th Amendment, since the 12th of August is the 91st day of the 8th Amendment? So can they reintroduce it and take it into second reading, third reading, Senate, and so on?
If we're treating it with it from the position that this 9th Amendment bill has been passed, yes, they can. At that point, the minimum 90-day requirement would have passed on the 8th Amendment bill. And we're not clear that that bill has actually been withdrawn in its entirety. There are lots of issues in that bill that, aside from preventative detention. So as far as I know, it hasn't been withdrawn. So that minimum 90-day period most certainly would have passed on that bill. And remember that there's nothing in our Constitution that requires that there be public consultations, at least not in writing. We will say to you that there's a convention that there should be public consultation, so the government should still, even though the minimum 90-day period has passed, they should still come to us and have those consultations. And I would venture to say it might be possible to, if they went ahead and passed it with no consultations, it would be possible to take a legal challenge. But again, we have this interesting Section 69.
Well, and just a follow-up question. You know, even last night, y'all were talking about consultations. Well, we know it's not even required. We know it's the spirit of the law. But the question is, when they do consultations, okay, what are they looking for? And what is the bar? Is it, of everybody that's there, 50% or 51% must say we agree? I mean, what is the bar? Is there anything in writing? I mean, this is a joke. I mean, what is the bar that we're looked at, that they've got a hurdle they got to jump over to say, now we have the right, we have the voice of the people have spoken? Where is that at?
You know, we don't know what the bar is, and it's not written anywhere. I would tell you that I attended the public consultations for the 6th Amendment bill, and what disappointed me is I hit Holy Redeemer Gate, and I was met with tons of people in their party T-shirts. They had bussed-in people with T-shirts on supporting the government, and they filled up, you know, at least 1/4 of the room, if not more. And then people started to get up and make their, you know, presentations or to have their say. And originally, some of those people started booing and heckling, and you know, it was a really horrible atmosphere. It wasn't one that encouraged people to actually get up and express any sort of discontent with what had been tabled. But in reality, you know, it's a difficult thing for us, because if we don't organize that way, you know, maybe the bar may have a few members of executive there, and whoever else wants to show up. Maybe the chamber might have some representatives, or if your members feel strong, they may go. But supposedly, 3 people from chamber go officially, 2 people from the bar. You know, that's nothing to compete with busloads of people saying, yes, we support you. We want the public consultations to be able to reflect the thoughts of the people, and whether or not we really, really agree or disagree with the points in the bills. But there's nothing written about what is the bar. They will walk away with a determination of, oh yes, we think that there's support for this bill, and I don't really know how anyone could tell them yes or no.
It's okay. You had honor?
Yes, the Constitution derives its existence from the will or the power of the people. If for say some reason tomorrow, through the popular vote during the electoral process, the people by a majority vote decides to alter the Constitution, would that decision be subject to judicial review?
You mean when you say the people...
Through the vote, the popular amendment by the vote. Just like they would have an electoral process.
Oh, you mean like if we went to a referendum?
Right.
Or so? If the people did go to a referendum, and they did decide at that referendum that they would want to change, and then the National Assembly proceeds to make that change, you could still review. You could still, as we stand now, you could still review or make an application to a court to ask the court to consider whether or not that legislation infringes your rights. Because at the end of the day, the Constitution, when it originally started, the intent was to protect the minority, not the majority. The idea was that the people would have their majority in the House, and you would always have these smaller groups who have concerns and interests, and they are the ones who would need the protection of a constitution against an out-of-control majority, if it comes to that.
Then the question I would ask is this, because the court to me then, it's a question of our inalienable rights, individually, collectively, and as a nation as a whole. We go to the polls and we say that this is what we want, and the majority vote this way. And the position that you are taking is that that can be subjected to judicial review. And that judicial review is simple to determine whether that decision violated your individual right, if you are an aggrieved party. You agree with that?
Yes, you can get there. I think the interesting issue in there would be exactly what we're going to be treating with, because something that's interesting is that the preamble of the Constitution, which was something that originally was thought should not be amended unless to include additional affirmations or beliefs and things, that's actually been amended twice as it now stands. So I think, you know, the reality is that if you go down that road, you want to make sure that everything is consistent. You can, for example, as a people decide we no longer want to have a particular fundamental right at a referendum, and then you can instruct through that process your National Assembly that you no longer want to have this fundamental right, and they pass that. But I suspect that you will go through the process of judicial review and the courts will let that stand.
Well, my final position is this, is that if the court is there to interpret it and to adjudicate and those fundamental rights of the people, then to me that even if the government were to succeed in altering the Constitution, I don't think that will bar the people from going to the court to seek redress. Because the state would not be in a position to do that. I think that what they are looking to do, to remove it from judicial review, I think that in itself will require the people to go to the court for a decision. Because I'm hearing it said by some of the legal luminaries last night too, I get the feeling that they are saying that once this is passed, it's the end of it. I don't get that understanding from our Constitution, that the people hold the power, and they give authority to the elected representatives to alter the Constitution, subject to judicial review. But if you go to change that, you cannot. So I am taking it that if the government should fail to listen to the people through some consultation, arrive at their own measurement calculation of what the people are thinking, and say they have the will of the people, as the former Attorney General is suggesting, that they will act on the will of the people by consultation. And of course they will do their own calculation of that power, the will of the people. But my understanding I get of the Constitution is that the people gave the elected representatives the authority, not the power. And that the alteration of the Constitution, and this was argued strongly in 1980 and 81, because one of the issues that was raised during the debate in this country throughout, how do we alter the Constitution? And the issue of power was brought out that only the people have the power. And the people give to the elected representative the authority. And if in the event that the court should be removed, because it came up from then in the discussions, it was said that no government, no National Assembly can remove that from the Constitution. That if they do it, you can go to the court and seek a ruling against it.
Well, that's why I'm saying it depends on what it is that you want to treat with. If you're going to talk about the removal of the judiciary, it's very unlikely that even if they pass the amendment, say for example, we say we want to get rid of the judiciary, then, or they claim the will of the people is to get rid of the judiciary. So the National Assembly passes that, and there's a law saying that the judiciary is no more. The suggestion coming from the judges, even in Britain, where there's a parliamentary democracy, they have indicated in writing in a case called Jackson that if you ever did that, we will pay it absolutely no mind.
Okay.
So you go ahead and you do it, but I'm absolutely not going to pay it any attention, and we're not going to enforce it. And in the face of that response, the legislation that government was looking to treat with, they actually pulled it back from trying to pass it. But yes, I mean, at the end of the day, if whether they go through and pass it, say we don't get an injunction, and they go through and they pass it, the Bar Association will probably still fight it. And then what you'd have to hope is that the court, in looking at how it is empowered under the Constitution and the structure of that Constitution, will recognize that for their own survival and for the Constitution to be recognized for the way the people expected it to operate, they will simply ignore this bill and rule against.
But one thing I would
declare it void.
I would like to ask the Bar Association is that those who are expressing their views on it, not to say that once it's passed, it's finished, because I don't think that is the way to be.
Well,
if for some reason I know that we should vote no to the people to get involved in the consultation and try to convince them not to support it. But I think it's the time of, I would say, the legal persons in particular, to begin to let the people understand that in the event we fail at that first attempt, and this thing should go through, there will still recourse to the court.
I take the point, because yes, even if it passed, we would still go to court. The difficulty for us is that there have been so few cases where government have sought to do anything like this, that we're not exactly assured of a particular position. And if you had a judge that decided, well, I'm not really bothered if they said I can only review procedure, so I'm gonna say I'm bound by the Constitution as amended, and then they dismiss our claim, we would have to fight through the layers to see where we get to, but fight we would. But there is a real possibility that a judge would say, the Constitution has now been amended to say these are all the powers I have, and I'm going to respect that amended Constitution, so no, I dismiss your claim.
So strategically, it may be better to tell them that if they should pass it, that's the end. And we're on the road to tyranny and anarchy.
Yeah, thank you. Yeah, Glenn?
Treated in here and try to help me understand, as I'm not of a trained legal mind. But let's assume for one moment that the 9th Amendment in its present form is passed. And somewhere down in the future, because one of the arguments I've heard is that any subsequent National Assembly can amend that. And so somewhere down in the future we elect a government who, under the powers therein, decide to abrogate private property at will, randomly. And the people, having learned from that, as I said, some futuristic government, decided that they will seek to change the government to get that act changed. However, the party, and assuming that we have multiple parties, that commanded the majority in the House doesn't have the requisite 2/3, or is it 75%?
To change this part is 2/3.
Yeah.
2/3.
Yeah, 669.
So they fail to have the 2/3 majority in the House, although the majority. And the other side, or sides, refuses to cooperate with amending it because they're hoping to get back into power where they can continue what they were doing before. Is it that we would then have a situation where we have a tyranny of the minority ruling the country? And how would we extricate ourselves? Because I'm presuming that the present government is a decent government that will not randomly abrogate people's property. But in the future, there may be a John Burns government that is a rogue and will take people's property in that manner. How do we then, what is the mechanism that is being proposed to allow us to extricate ourselves as a nation from such a scenario? Or is there any?
Without this bill, how we treat with it is we go to court. We don't care which government. The bill has passed. Yeah, assuming it's passed, and then our judges somehow don't help us and say we're going to stand by this new constitutional regime where we can't look at the substance, then we just stuck with it. That's what it is. You just have to live with it. You have to live with it until somebody or some administration takes pity on us and changes it back.
No, if you don't have the 2/3, you can't.
Well, this is what I'm saying. Until eventually down the line, you stuck with it. Because the reality is, for example, preventative detention. Say it was passed now because we have a supermajority, and that involves a fundamental right. So they would have to have the supermajority. They lose the election, the next administration comes in, they don't have the supermajority. They can't touch it. They can't touch it unless they can somehow come to some sort of agreement. And a problem that we have, not just in Belize, I think, or I think it's a worldwide problem. Once you have rights taken away, you try and get them back. It doesn't happen. You will sit there hoping that the next administration will give you those rights back. But that's not the easiest thing to do. It doesn't always happen.
One of the things.
But even if you, but say they pass preventative detention, can't you challenge it in the courts?
This is what I'm saying and what he's saying. Right now, I would most certainly challenge it in the courts. But if I'm meeting the block and the courts are looking at this thing and saying, I'm going to abide by it, then I'm locked. Because the courts would have been the only place I would have had to go. That is the only other place you can go. And if the courts are telling you, I'm going to hold to this, I'm going to respect this, then you're locked.
One of the things that I think this is doing, and I am really excited over this amendment, you know, when I first heard it the first day I said, thank God, it's the best thing that has ever happened since sliced bread. Because for 30 years, and certainly for the last 20 in the chamber, a group of us have been fighting for some serious constitutional amendments. Talks headed that. We worked with former Minister Joe Koi. We worked, Senator Garden and myself been doing shows forever. Kevin, myself, and Senator Garden, Kevin was then the GM of the chamber. We did a complete and comprehensive review. And we didn't do what was flippant. We wrote the entire thing over with the assistance of some serious legal minds from overseas and various people who are constitutional experts. And when I saw this, I said, for the first time, it's going to wake up the people of Belize to what can seriously happen to this constitution. One of the things I have advocated from the day we got our independence is that since this is the people's law, it should reside in the people's for any change. And then I heard the 8th Amendment, no, the 6th Amendment, when Senator Schuman said, why not put in the Constitution, in the fundamental rights and freedoms, a provision that any change to that required a referendum to do it. And then, if you follow what has happened so far, the first thing that happened since 2008 is that the Referendum Act was amended because it did have a provision in there that if you were going to tamper with the fundamental rights and freedoms, you had to go to referendum. That was changed. And the Referendum Act was amended to simply solicit views and no longer had any mandate. So you could scrap that one. And then there was a provision in the Constitution at Section 69A, which required the Senate to pass any amendment that would amend or alter the fundamental rights and freedoms. That was excised. And then there was a provision that required the Senate to approve the appointment of judges. That was excised. And then now we get to a provision which is excising the courts. If you look at the gradual slippage, which I have been saying over and over, and it's slippage. This particular amendment to enshrine utilities in the Constitution is not here nor there as far as I'm concerned, because first of all, it falls under the 2/3 majority. And Section 69 itself falls under the 2/3 majority, and I just simply told you that could be changed in a day. So this doesn't really give any serious protection, but if you wanted to do it, let's say you wanted to do it, then you could have simply amended Section 69 5A to say, without touching the courts at all, you could have, and I thought that's what the Prime Minister was going to do when he introduced it in the House, and I was listening carefully. He simply could have said to 69 5A, for those of you who have it, that in fact, he was going to then reside, 69 5A says, subject to Sections 78 and 79. And this is where they made the Senate really wawa. Says of this Constitution, a bill to alter any provision of Part 2 of the Constitution shall not be regarded as being passed by the National Assembly unless it's supported by a simple majority of the Senate. That says absolutely nothing, because a simple majority of the Senate is the government side. And they always say aye. And then you remember there was this bold move to create a 13th senator, which would have changed that position. And of course that was crap. So, well, it's on hold. So you can't win, man. Now all he had to say was that, add to that, and provided that any amendment to Section 143 to 145, which is the new BTL section, would require a 2/3 or a 3/4 majority of, a 2/3 majority of the Senate to make it consistent with the House. And that would have locked it right in. You never needed to touch the courts or do anything. You never needed to do any of that. Could have wrote this on one page, that we're making this 51% and we're locking it by 2/3 of the House or 3/4 of the House. And if you don't want to be so generous to the Senate, because I don't like me or others, put 2/3 of the Senate. And you got it locked in. Got it locked in. Because no government is going to have, under the present Constitution, no government, no matter how much majority they have in the House, is going to have more than a simple majority in the Senate, the way it is now constructed. And so, simple things you could do without dealing with the courts and making all these amendments, and it never needed to come. But I see these things and I say it without apology. It is just like how we passed the amendment to the Indictable Procedures Act, and those were passed on the same day that we did the bill for BTL. And nobody, I mean BL, sorry, and nobody noticed it. It was done June the 20th. Slipped right under the radar because the hype was BEL. So you didn't realize that you passed some serious amendments to your fundamental rights, became law, just like that, poof. And you say you have the people's support. So if you're serious, ladies and gentlemen, the move should not be to be arguing about the courts and all. It should be arguing how we amend the Constitution to reside the powers of changing this in the people seriously. That is your only safeguard of your fundamental rights and freedoms, to my mind. And nothing else, unless somebody else can tell me. Don't reside it in elected officials, reside it in the people. You want to change any of these rights and you list them. Section this, section that, section that, section that, must be done by a referendum of the people in which so many people vote and this percentage pass. Then I go in with that. Then you can say truly. Then the honorable minister get up and say, man, we can't do it, man. The people said, the people said. Then it would seriously mean the people said. You don't do that, you could tell me all you want, but the people say.
I just wanted to endorse the Senator's comments because, you know, the Bar Association too, we put a constitutional together, you know, back from Mr. Harry Courtney, yes, and those recommending substantial changes to the Constitution to protect rights. Government didn't, they treated with some of it, but not the key things that we really wanted. We then put another committee on it subsequently, did the same things. They accepted proposals like inclusion of the chamber and all these types of things, but they refused to change the numbers on the Senate. When we got to the 6th Amendment bill in that referendum act, the Bar Association was out there. We were talking to people, we got the position paper out. But remember that those amendments were tabled in the first, 100 days of government winning the elections. So to me, I call it our honeymoon phase, because nobody wanted to hear. They were like, yeah, but this is our new government and they need to do things and they want to make changes. But we're saying, listen, the entrenchment provisions are being removed to make it easier to take away your fundamental rights and freedoms. Why are we taking away entrenchment provisions? And it's clear in the paper, and we were saying it. If you're going to repeal the section in the Referendum Act requiring a referendum for fundamental rights and freedoms, why not put it in the Constitution?
Exactly.
We said it to them from then, and we met with them and we said it then, and they wouldn't do it.
No.
And to me, that was a signal that if you don't want to put something like that in the Constitution, then I know exactly where you're going with this. And it's just been a fight ever since for the same things. And we still have the problem, because the issue of the Belize-Guatemala dispute is still in the Referendum Act and not in your Constitution.
Yep.
So as government said in the Boeing case, if I want to change the territorial borders, I can do it, and you need to stay out of my business, provided I have complied with the procedural requirements. So you could have a situation just like the Sixth Amendment bill, where I repeal a provision in the Referendum Act. Easy style, because it's not in the Constitution even. That's a simple thing. So now, no referendum to deal with the Belize-Guatemala issue. And then you go into the Constitution, and you go into National Assembly, you change the Constitution there too. So, you know, at the end of the day, we don't understand why you think that we should be making it easier to amend the Constitution, especially in relation to fundamental rights, instead of harder. Yeah. There is a problem.
The one comment following up on that I would make is that while we continue to, and then last night I thought that the Solicitor General erred deliberately when she said that in fact this is only law, the Referendum Act is subsidiary legislation to the Constitution, and therefore in other territories they're not putting this. I don't give 2 pints of pee about other territories. I'm concerned about Belize. And besides, you cite a whole lot of failed territories to me. You know, cite the ones that are doing great, like Sweden, Switzerland, and some of them that have direct representation for laws. Please, man, give me the good ones. Don't give me the wawa one where they stumble. We don't want to be playing around with this. We want to be dead serious here. Maybe it's because of my age and I figure I got that much long for the wrong. So I don't got time for play games. If we're serious, okay, if we're serious, get it in the Constitution, reside it in the people. The principle is what is correct. The principle is that this is the people's law, even though we all didn't sit down in 1981 and write it. But the preamble clearly points out the things that we as a people want. And the rest of the provision in the Constitution is to give effect to that. It says, how shall you attain this? You shall attain this through these various mechanisms. That is what the Chief Justice said. You can't dismiss that. And I take great objection to the fact that the Honorable Minister said that the Chief Justice was in the clouds and he would have had a lot of rain if he was still around. That is disingenuous. But the point is, he was absolutely correct. And so, if this is what we the people want, we must as a people solidify them and say to the government, look, you are not all powerful, please. You are representatives of us. The Constitution gives you certain administrative rights and other legal rights, but please, we hold the chips. Because I could argue right now, I could say that if the government is so omnipotent, so all-powerful, and so infallible, how come the National Assembly, which included me, and all of us sat there, 42 of us, to make a law to acquire BTL, and it goes to the legal minds and the proper constituted authority, the judiciary, for review, and they said, you know what you all did over those 2 days? Rubbish, because you didn't make a good law. Couldn't we make the same mistake if we are amending the Constitution? Couldn't we make the same rubbish? You must take it to the competent authority to say, you know, maybe your intent is good, but what you did, how you did it is not good. So please go back. You can't lock that process out. Particularly since we all know that the legislation is drafted by the Solgen, or drafted by one person in the ministry, and then it goes to the cabinet who has very little legal expertise. It goes to the House who says rah, 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 and aye. It goes to the Senate who says we want to try to get out there, the ayes have it. It goes to the Governor who put a pen to it, and thing done. And then you will say this is an infallible law. Can't touch it, can't look at it, can't nothing. Please, man, could we stand up for that?
Godwin, I have a comment and a question. The comment is, every time I come to the chamber meeting, the chamber, I think, needs to take a more proactive approach and become participatory in this process. We need to work together as a group to try and get our voice out there, and I think we don't have a voice. We have maybe a voice of A and a few members up front, but I think as a collective group we need a much larger voice, and we need to find a way to protest. And the second thing is, as far as the atmosphere of investment in the country, I think things like this can seriously affect business opportunities and investors looking at Belize as a potential place to invest, and I think that's a serious concern for at least business people. I think it's something that is very scary for a lot of business people. First, if you think about countries like Zimbabwe and Venezuela to a certain degree, and it scares, I think, investors, and it scares the business person who is here in Belize and trying to make an effort. It certainly is very negative.
Thank you. There's just a quick comment to that. I think that if you look at our history, and certainly during the 2005-2007 era, when you had a very strong government, the chamber stood up for some very serious issues. I think we do continue to stand up, but somehow it requires a kind of clarity of our membership. Somehow in this country we are easily intimidated, we get afraid of, things happen to people, and we recoil into a little corner. I think the reason for that, though, is because sometimes we don't hold on to issues strong enough that burn in us. So I put an issue out here again for this very 9th Amendment or any subsequent amendment. If it burns strong enough in the people of Belize that they would say, or be prepared to demonstrate, or prepared to do anything to say, look, boss, you did do whatever you do, but when it comes to rights, you ask we. If that burns strong enough in you, and if that can get beyond the partisan divide and beyond all the silliness, we would have moved a tremendous step in this country to secure those rights. And that would be a simple amendment to the Constitution, and one that all parties could support.
Yesterday, sorry, just to follow up. Yesterday, I did not hear the entire debate, but Senator Gordon mentioned that he had a proposal as to how to amend this constitutional change to make it more appeasing for the government, and I don't know how that was received overall. Was that very receptive, and do you believe as a group that the government is willing to remove some of those draconian and very restrictive portions of the Constitution? Are they willing to be able to be receptive to that? And
Well, Mrs. Marshall will say that third-hand information is absolutely not admissible in court. But I'm going to suggest to you that Senator Gordon headed the new governance commission which was set up, that they worked for 22 months, that they came up with a draft of some very serious amendments which he shared with me, which he presented to cabinet, which was absolutely rejected. And therefore, I'm going to say, and he also was kind of given the green light by his minister, the minister responsible for that area, who was Minister John Saldiva, that he could release those proposals slowly through the show that we do and to the public. So if I may say that the government is not amenable to accepting them, I think that is an answer.
Dean, I want to thank you for what you said a couple of minutes ago when you started your comment to Senator Hulse. I have a very unglamorous suggestion for everybody present, and it's a suggestion I've been making for the last couple of meetings. We here represent a body of people, each of us does. We are employers. Some of us have more employees than others, but each of us is here because we're an employer. We should be talking to our employees about what it is we take away tonight from this. We should be talking to anyone that we can talk to about what we take away from this tonight. The fact is, I think out there is a, well, I don't think, I see. There is a deliberate attempt to obfuscate the matter, to deliver a message that, this is no big deal, it's all about the nationalization, and the rest of it, well, you know, there's already ouster clauses in the Constitution, so, you know, what it's saying in the 9th Amendment is no big deal. If it was no big deal, why is it there? That's the first question. The next thing is, it is not just about the nationalization. It is critically important to the future of our democracy what happens with the 9th Amendment. That, I think, is plainly obvious to everybody who's listened tonight. And to quite a few who listened last night, I'm sure. But the thing is that you guys have to decide what you want to do about it. And as the chamber, Dean is perfectly correct. We have to get out there as one very strong voice and say what needs to be said. But the unglamorous part of that is that we need to speak to the people that surround us every day and make sure they understand what it is they're getting into. Because I don't think that the general understanding out there is too clear. So let's leave the clouds at home. Let's be perfectly clear about what the 9th Amendment is and what it means to all of us. And let's begin to talk about it out there. 90 days isn't a hell of a long time. It's gonna pass very quickly, and we're gonna end up with a nasty surprise. And sorry, Mr. Coy, but I don't want to gamble that it can be reversed in the courts. I'd rather find a way to stop it. Since the government says it's about people power, let's find that people power and show the government what the will of the people really is.
There's a piece in the legislation, again, that Mrs. Marshall touched, but I want to pronounce it a little bit. When I did the Social Security investigations and we had concluded our report, there was a request by the then General Manager of the SSB, Mrs. Garcia, to have a look. I checked with all the legal authorities. I checked with the then Counsel for Court. The provisions in the standing orders which are govern the National Assembly were very clear. They could not be released until you presented them to the Senate. We did so. Mrs. Garcia took us to court under the principle of the violation of the rights under natural justice. The courts upheld that right. I learned clearly that no matter what the National Assembly does and says, persons have that right. If you look in this document, it simply says, and I want to read it for you so you're clear. It says, the bar on the jurisdiction of the court contained in subsection 1 above is absolute, and no court shall assume jurisdiction on any grounds whatsoever, including without limitation any alleged ground of lack of jurisdiction in the persons making the said acquisition orders, or any ground alleging breach of the rules of natural justice. It is not something to be taken lightly, because the principle of natural justice goes back to Adam and Eve and God, who simply said, you know, I give you a chance to be heard. That is where it emanates from. Everybody has a right, no matter what the law, what the rule, what the structure says. It rides over everything else. And when you bar that, you're moving into some serious and dangerous territory. Please, man. In a civilized society, we try not to do this. We try to broaden the democracy. We try to create, hopefully, more people participation. We try to reduce government control. We try to create a society that the British were prided themselves on. They said, we are ladies and gentlemen. The laws here are to guide us when we have doubts, not to control and rule us. That's why they don't write their constitution down, because they would not dare to do anything wrong. Please, man. That is where we should move to, or beyond, not the other way around. Questions?
I just wanted
one question. In jurisdictions, I think you cited India, Bangladesh, and some others. What triggered the amendments in those jurisdictions?
In India, they went to court. Basically, I think there was some property that they wanted to treat with, and the court had struck it down. And so they went back and did it again, and the court struck it down again. And then it got to the point where then the discussions moved into how you deal with the judiciary. So they wanted to bring these clauses saying, why don't we just get rid of them if we have to, that type of thing. And so then the courts had to develop this doctrine that we're talking about. But that's essentially where it keeps going. You know, it isn't something that happens in a lot of developed countries, because really people don't treat with constitutions in Australia and those types of countries in this way. So you're not going to find lots and lots of examples where this has actually happened and you get a decision. There are really very few countries. But it just comes back to the courts having to be, I wouldn't say imaginative, but they really have had to figure out a way to stop the excesses of the state. Because you're moving into these provisions which are saying, I am going to do this, and the court can't tell me anything about it in all of those countries. And so no, they said no, we're not going there.
Docs.
Okay, I think you're right in saying that 90 days is not a long time. I think we've heard enough, and I think it is about time the chamber starts flexing its muscles to show what power it has. These are messages to us. We need to be sending back messages as to what we can do if we don't like what is happening. If we wait too long, we talk too much, we talk to our employees, yes, that works. But I think a lot of talking is happening and no action has happened as yet. There's a time to send a signal, a small signal. There's a lot of ways of doing that.
Joe?
I just wanted to clarify a point that when it comes to the court, I was only seeing that as a last resort. Certainly not to wait for that. But I think now that I'm beginning to hear people talking about what measures will the chamber be taking, and I think that is what we should be focusing on. I know the consultations, I think, will begin next week, and that's a place to go to make sure there are enough numbers there to speak out against it. But I agree with the gentleman that spoke last, that probably the chamber needs to begin to look at what sort of methods and measures, militant moves that should be taken to bring the message clearly that they are not going to support the amendment. So the legal part, that is only a last resort, but I agree that, and I take your point, that we must go out and talk, but I think we need more than that now.
No disagreement here.
I think I just wanted to also make mention of, I think this is a really, really critical bill, and I think for Kay as president and myself as president, serving members of the executive, we have felt the heat from time to time when you step out and you disagree with this administration. It's been a very disappointing fight, trying to get them to understand that when I say I don't agree with this particular legislation, it has nothing to do with whether we vote UDP or PUP. When we pass our resolution in relation to the judiciary, we did so with a majority, a unanimous majority. I think maybe one abstention. That's how those amendments went through. So it wasn't just a group and then you get thrown in your face your PUP. You know, we come to this 9th Amendment bill and we have our UDP attorneys also saying we don't like this bill, but yet you're not getting anywhere. And now the response is, she's an Ashcroft girl, she's not even Belizean, she wasn't born here. I mean, an absolute ray of absolute trash. And, you know, I'm just at the point where, you know, even for me, I think that this really is about the bill. When I saw it, I was really horrified. Things started coming to my mind like, maybe I should do a hunger strike, and then but I have children, so I can't do that, you know. But it's really, really serious. And, you know, if the Bar Association needs to work with Chamber, or Chamber and Bar need to work with whoever else, and whatever we have to do as a group, then I think we need to do it. Because the concern that I have, that I also hear, you know, on the radio coming is, who is the Chamber, who is the Bar? They're just a little bit of people. They don't speak for the masses. The masses say this, that, and the next thing, and, you know, why don't we count? We have a say. We pay taxes. We employ people. We make our contributions. Why don't we count? And don't even say the PUPs don't count. PUPs are citizens too. The government is there for all of the people. PUPs, UDPs, and no Ps. But always the divisiveness is nasty. The response is really terrible. And there's a lot at stake for the government. But what I want to get across to them is that nobody is really in your way in terms of your policy decisions. We certainly all would have liked to have been consulted a little bit more so we could figure out a way forward. But at the end of the day, we don't agree with you. And just because we don't agree with portions of this bill is no reason to come back at us in a way that is really offensive. And unfortunately for me, you know, we have tried repeatedly since we took our stance with the judiciary to reach out to government, and we have, you know, I invite them to meetings, I get responses, one line, I can't accede to your requests. You know, we asked them for the 8th Amendment, we asked them for copies of the bill or an outline of what they wanted to do so we could work with them on it, give them comments. They didn't even answer the letter. You know, I don't believe that the attitude that is coming back and how they treat with these things is adult enough, and it really isn't to be encouraged. Yeah. And it's just, we have to figure out how we move forward in a way that gets the message across, but we don't get divided again as a group.
Right. Let me say that for those of you who would have copies of the first constitution or even the white paper that went to London, and I think I could make it available, I have it in my files. When the constitution was first written and they looked at the divisions, there was a provision that limited the size of the divisions so that they will be more or less equal. You remember that, Joe? That provision was there. The concept of 24 elected representatives meant that 24 elected representatives would more or less represent 3/4 of the voting public. That was the concept. So since they're speaking for us, if you look today at how the House is constructed, you will note that while in the last general election, the United Democratic Party picked up 56.37% of the vote, and the People's United Party picked up 43 point something, and there was a small difference there. The House is constructed where the United Democratic Party has 90% of the holding of the seats, and the People's United Party 10%. It's very disproportionate. And so, when you take 3/4 of the House, and I continue to argue this, I threw these numbers out 2 weeks ago on Love FM, and it created quite a stir. The entire votes that the cabinet got is 31% of the people who went to the elections on that day. The entire vote of the entire House is only 52%, 53% of all the people who went to election on that day. And the 24 that is required to amend our constitution is only 47% of everybody who went to the polls on that day. So those numbers should mean something to you. I continue to say, you want to protect your fundamental rights and freedoms, the first move is for the Bar Association and the Chamber and other concerned people to redo the 9th Amendment in a way it should be done, which enshrines this in the Constitution, what you want to do without all these things, and introduce another amendment to ensure that the fundamental rights and freedoms are enshrined in that Constitution, period. And that provision could only be repealed on, and think the number, on unanimous vote of the House. The only way they could repeal that would be, let's say, unanimous. Let's get creative and let's get strong and say the only way you repeal that provision ever if you get 100% support in both houses. That way you lock it in forever. And don't tell me it's not done in Jamaica, or it's not done in Guyana, it's not done here, and it's not done there in the Westminster model. Let the rest of the world see what we do and how they could protect their rights and freedoms. That's the way to go, not the other way around. And so, we have all the legal minds to do these things. That would be the first move. And that is something that you can sell. I'm telling you, you could sell it on CREM. You could sell it on any of the stations that are radical, that you want to reside the fundamental rights and freedoms of the people of Belize in the people of Belize, and not in any elected representative. And no matter who is it, not even me if I was there, please.
But Godwin, if I could add to that, you said we need to get strong, but the only way that we can get strong is through our membership. And just to look at the turnout tonight, I mean, we have so many business members, and this is just a portion of. We really need to reach out to other members who are not here. We need everybody on board. If we're to be more proactive and take action, we need numbers. We can't just go with just a handful of people, because like what Jackie said, you get targeted. If there's a group, how can they point a finger if there's a big group of people representing the chamber, the bar, and any other association who wants to join? So I think that is important for us to leave here with tonight as well. We need to reach out to other members and let them know that, you know what, this is the action that needs to be taken, but we need your participation. We need you actively participating in whatever decision we decide to take from here on.
And what I'm saying is to answer Dean's question about investor confidence and everything else. Since we have those provisions that protect the right to property and ownership, they all come under the fundamental rights and freedoms. I don't know anybody in this country who would be prepared to stand up and say, you know what, I don't want to have a say when it comes to my rights, etc. Mrs. K. Menzies and Mrs. Marshall chronicled some issues that happened to them when they stand up. You don't want to begin to hear mine, right? It happens all the time. We know the whole story, so please, let's protect the rights. I don't even want to leave it to no court that might be iffy. I don't want to have to go to court to see how they want to think. Particularly now since the judges are appointed directly by the Prime Minister. The Senate now have no say in that. Anybody may know Chief Justice may get appointed. The interview come, bam, bam, appoint done. Now you see when he walk in there now. So please man, all of these changes have happened. I don't want to reside my future in anything except myself and the collective wisdom of our people. Those are the fundamental changes we want. We get that, then we talk reform, then we say we're good to go. And then you can see all these lot of little changes coming and say, that's okay, it's all cosmetic, because if you want to make any big move, you have to come to us. That's the way to go. Any other questions?
It's been said that Belizeans have always been complacent. Now, we're finding out what that complacency leads to. Are we going to continue to be complacent, or are we going to take the minister's advice and let the people speak, tell the leaders where we want to go? My advocacy email signature says, when the people lead, the leaders, if the people don't lead, the leaders will lead us astray. If we don't lead the leaders, they will lead us astray again and again and again. How long will Belizeans continue to be complacent? When we see a meeting like this, who shows up? Where are the other people? Maybe they think they'll see it on TV. Maybe they'll get it on the news. And how is the news reported? How accurate it is? I think unless Belizeans wake up and demand our rights, they'll be given away, sold out, left behind. And then all we can do is say, uh-oh, we didn't know that was going to happen. If we didn't help to make a change, then we take what we get.
Yeah, thank you, Mike. Any other comments or questions? In that case then, I'll ask Ms. Farid to do the closing remarks, and thank you all for having joined in and the start of a new peaceful, constructive revolution, it was called. Thank you very much.
Thank you, ladies and gentlemen, for giving this highly utmost important issue your attention this evening. To the Secretariat, our President, Senator Holtz, a big thank you. To you, Mrs. Marshall, President of the Bar Association, thank you for coming out this evening and disclosing this information to the point that, to a level that we can better understand. It is our philosophy at the Chamber to champion the people's will, to foster timely connection, and to capacitate each and every one of us with knowledge. Let's keep this in mind. Will of the people, will of each and every one of us. And if I can borrow the words of Evan Exide, power to the people. Thank you.